it reinforces the wounding notion that they are to be treated as biological oddities. It's rather well put, Paras. As failed or lapsed human beings who do not fit into normal society, and as such do not qualify for the full moral concern and respect that our Constitution seeks to secure for everyone. It signifies that their capacity for love, commitment, and accepting responsibility is by definition less worthy than that of heterosexual couples. Whereas if your lordship were to look for the philosophical underpinning, but I say also the core constitutional value underpinning, this is rather well put. And I'm always, of course, it is L.B. Sachs, we know that. It's L.B. Sachs. But L.B. Sachs also could not have, he has bested himself. He's written some very, very good passages, but he has really
bested himself. Have you read his book, The Strange Alchemy of Law and Life? It's a brilliant book, actually.
But here, in a very, very pithy manner.
L.B. Sachs, there's a great story about L.B. Sachs. Sachs was very closely associated with the African National Congress.
Yes.
And, when he was driving his car once, a bomb was placed under his car, which blew up, and he lost his arm. And
I believe there is a Netflix.
Then, the Truth and Reconciliation Commission was instituted in South Africa. And Sachs has narrated the story. He went for an evening, so he was having a drink at the bar, when someone came and said to him, well, somebody wants to come and meet you. So he said, he was intrigued. So he said, well, that person can come and meet you. Can come and meet me. The person who came and said hello to him was the very person who had planted the bomb under his car.
Yes.
So, then Sachs speaks about, his sense of forgiveness and
he heavily influenced Mandela and the whole system for that concept of truth and reconciliation. He was But this is, if I may say so, one of the best legal statements. I have put it in my compilation, and it is almost now, elsewhere in the early part of my submission, which I have not read, we have identified 33 examples. 10 examples in 10 different countries are like this, of judicial interpretation consistent with constitutional values, not doing violence to values, bringing in marriage recognition for same-sex persons. Those 10 countries, for your lordship's information, would be Austria, Brazil, Colombia, Costa Rica, Ecuador, Mexico, South Africa, your lordship just read with me, Taiwan, and of course the US. And about 23 have legislated it. They're both examples. But these 10 I have given.
Some others which are the European Human Rights Courts, etc.
Yes.
Russia.
Not sovereign domestic courts, but the human rights.
Transnational court.
So now it's expanding. This is an earlier list of about 33, of which 10 are judicial.
The earliest one was perhaps England.
Was Malas?
England, UK.
Yes.
England.
Yes. So therefore, Malas, and I'll be coming to a very interesting because England is believed to be much more timid, restricted, and circumscribed in its in the acrobatics which anybody can do in judicial review. I will give you an extraordinary article and 2 cases. How far they've gone on interpretation. Of course, identical to us because we have the Constitution. So, Lordship is looking today at a Constitution compliant interpretation, if I may use that word. They've done exactly the same for a treaty compliant interpretation.
That's because of the Human Rights Act.
And they've gone. No, but
the Declaration of Incompatibility.
I am surprised at the stand of the government of India. Your Lordships, not only has much more power, but has gone much further. In that case, I will cite, they've said that it is wrong to think that text of the statute is a limitation. It is wrong to think that even intent is a limitation. With evolving dynamics of time and society, the 2 tests are to make it treaty compliant, which is exactly the same as constitutional compliant. The underlying thrust of the legislation, and B, the institutional capacity of the court. And by institutional capacity, they've explained further to say it means that unless the court feels that it is being asked to naked usurpation of legislation, namely, whereas your lordship goes beyond the limit, not doing some legislation, but your lordship is virtually asked to transgress all limits and become a legislator. Barring these two, it is wrong to say that the text is a limitation, because they say text evolves over time. And intent also evolves over time. And these English courts are saying this. This is a beautiful article which I also will come in. That will take some time because your lordship's approach to interpretation is identical today. If your lordship accepts it this way or that way, but the test is the same. Your lordship is looking in the first part of my submission not to strike down anything. Your lordship is looking to make the
compliant.
constitutional compliant. Those judges in that article tells your lordships how they were making it treaty compliant in identical situations on an evolving dynamics of society. Then, Mullets, there is another facet, Mullets, of manifestly arbitrary. Your lordship knows, Mullets, Article 14 to just digress. It's important to digress for 30 seconds, Mullets. Till Mullets, Royappa, etc. I mean, broadly, as there have been earlier cases, your lordship had only, Mullets, the discriminatory aspect. Then your lordship got the arbitrary aspect, just developing nascently in Royappa. Then your lordship carried that arbitrary aspect much further in Maneka, Ajay Hasya, and all those cases, Mullets. And now, Malas, your lordship has turned Malas, Mr. Benegal Rao and Mr. Frankfurter over in their grave by bringing in full due process. He picked up the Japanese constitution and put it in Article 21 because Mr. Frankfurter said, look, you do anything you like, but don't do this. Your lordship, Malas, camouflaged it by calling it procedural due process in Maneka.
Actually,
Now we brought in
Mr.
substantive due
Now,
process.
Malas, substantive due process.
Mr. Rao must have been shocked even within 2 years.
And Mr. Malas, Frankfurter would have died a second time, Malas.
Justice Fazal actually imported it.
Yes.
It just took another 20 odd years.
And Malas, after Maneka, where your lordships kept the pretense of procedural due process for a few decades, your lordship now has all of them, Malas, Talaq, Triple Talaq, Joseph Shine, any number of cases, manifestly arbitrary, which is nothing but substantive due process. Now, with that background in mind, kindly consider what your lordship is today judging, Malas. Your lordship is allowing the creation of hierarchy between different conceptions of the family. It's another way of looking at the same thing, conceptually, Malas. Your lordship is allowing distinctions foul of 14, 15, 16 by Malas having a hierarchy between different conceptions of the family, involving unions between some kinds of persons more equal than others to have unions. Of course, again, based on their descriptive characteristics. So, hierarchy, which is a sub-classification, your lordship will not allow in Article 14. Of course, it's another angle to look at the same thing. Don't allow hierarchization of family units between those penalized for their descriptive tendencies versus heterosexual couples.
Yes.
Your lordship's brothers actually said this. Of course, not the ratio of the case, because my lords were dealing with a narrower issue about a mother with children from the first marriage. But your lordship's principle is clearly stated in my lord Justice Chandrachud, as he then was, in Deepika Maras, atypical family units. And the para is 26. Lordship will note that para. That was cited but not read. It was cited by Mr.
Gita Hariharan. Gita Hariharan. Which one?
Deepika Maras, 22. That is, Maras, in your lordship's compilation at page 84 at 91. Just read that one para, Maras. My lord has put it very pithily. Atypical family units, referring to Maras, queer relationships, equally deserving. Kindly turn to that page, Maras, just for a minute. Para 26 is that page. Is it 60? Page 91 PDF.
91?
Yes.
Volume 1. Volume 1, Sanjay. Volume 1. Para?
Para 626.
91 PDF.
Page 91. Huh?
Page 91.
91 PDF. Returned.
That's the hierarchization created wrongly, I say, Malas.
20.
May I read?
Yes.
The predominant understanding of the concept of a family, both in the law and in society, is that it consists of a single, unchanging unit with mother and a father who remain constant over time. This is very important, Malas. This is meaning of conception is changing. This assumption and their children. This assumption ignores both and the many circumstances which may lead to a change in one's familial structure. And the fact that many families do not conform to this expectation to begin with. Familial relationships may take the form of domestic, unmarried partnerships or queer relationships. A household may be a single parent household for any number of reasons, including the death of a spouse, separation, or divorce.
One.
I'm interested in the second part of this, but just read the next few lines. Very pithily put. A household may be a single parent household for any number of reasons, including death. Similarly, the guardians and caretakers who traditionally occupy the roles of the mother and the father, inverted commas, of children may remain, may change with remarriage, adoption, or fostering. These manifestations, this is what I'm interested to read, in particular. These manifestations of love and of families may not be typical, but they are as real as their traditional counterparts. Such atypical manifestations of the family unit are equally deserving not only of protection under law, but also of the benefits available under social welfare legislation. The black letter of the law must not be relied upon to disadvantage families which are different from traditional ones. The same undoubtedly holds true for women who take on the role of motherhood in ways that may not find a place. Well, these 6 lines in the preceding in particular sum up, Balas, the Article 14 aspect which I am making separately. Atypical does not mean, Malas, the atypical application of the law. And today, Malas, when your lordship has crossed the threshold of even substantive due process, we are today being told that your lordship is, Malas, doing something.
Thanks.
Very lordship embarks on this. This completes my first, Malas, and the most important pillar, non-discriminatory equal treatment. Second is, Malas, freedom of expression. Freedom of expression, Malas, I had the privilege of arguing Naveen Jindal. I remember, Malas, Justice Khare carried it from court 6 to court 1. That matter with him kept on getting adjourned. The government of India, Malas, and Mr. Raju Ramchandran was the ASG at that time. A matter against his heart and instinct, I believe. But anyway, he did his duty, Malas.
So Naveen Jindal later became my client because he didn't hold it against me.
So, Malas, there people tend to forget the right to fly the flag. Malas, we gave submissions. The SEC has published those submissions. 19(1)(a) expression. But there's one part of that, Malas, is that speech 19(1)(a) extends to quote unquote socially valuable participation in socially valuable forms of expression that are articulated in community. That's the facet I'm underlining only, Malas, for your Lordship's consideration. That's in Naveen Jindal, para 90. And Malas, the socially valuable forms of expression articulated in community, the participation within which is essential to be complete, is Malas also applicable to this case of exclusion. I'm not reading Nalsa because it's been read, it's been referred. I put in my submissions. I'm strictly avoiding it, Malas. But my point in one line here is freedom of expression includes the freedom or the right to express one's gender identity in all its manifestations. That's the my proposition as far as this topic is concerned. Now, Malas, if you are in 191A, and it's a straight point of 191A, we don't need to Malas, spend time on 191A. This phrase is sufficient. These two phrases, Malas. Participation in socially valuable forms of expression in the community, and freedom of expression includes the freedom to express one's gender identity. These are the two principles. The question arises, under what part of 19.2 can you touch it? Which 19.2 have you shown to the court? That's the more important aspect. It can't be, it is not. There is no reference point to any facet of 19.2 which there cannot be. You can stretch decency and morality. You can stretch decency and morality.
Is in action to
Down on 19.2, there is no law which is a reasonable
There
restriction.
is none.
14, yes, 14, 15, whatever. But the silence of the law to be construed as an
I'm very grateful. That's the second aspect. Today, your lordships has got, well, first, let us forget the silence of the law. First point is, if a law was made, I'm now going very much further against me than I need to go. Which part of 19.2 can it be relatable to? When the core values of the constitutional lordship is already discussing.
Then we are into an
academic question, correct? But decency and morality, you cannot stretch anywhere near to this. Your lordship is talking of constitutional morality and all the other.
Talking of,
Number two.
no, if so that's a hypothetical situation that if
I
you make a law and exclude today,
you may test it later on if it may.
today, otherwise today is a default argument.
Now,
you have not made it, you have not included it in there. Therefore, you read it in this.
No, but I'm only saying something else. I'm saying hypothetically only. I'm saying only hypothetically. My Lord Justice Bhatt is right. I'm saying hypothetically, the very text of 19.2 doesn't make it easy to think of a law which can be made, but I understand it's only hypothetical. It's an hypothetical argument made to show the contrast. Second, it is much worse because, I'm sorry. Now, the third and the last prong before I come to the very interesting interpretation part is the dignity point, which your Lordship is well aware, Article 21. I'm sorry, I forgot. I'm very sorry before I leave that. Well, it's this last part. This is actually the intersection. Main is Article 14 and 15, 16. This last point is an intersection of 14 with 19(1)(a). The right to express one's gender identity is being questioned by the state, of course, without a law under 19(2), questioned on the ground that what right heterosexual couples have to project that identity, non-heterosexual couples do not have. So it's an intersection of 14 and 19(1)(a). The projection of the gender identity, which is a part of free speech, free expression, is inhibited by your stand, which allows that right unfettered in your heterosexual category. And Malas, if they can't do it for a heterosexual couple, because your Lordship will undoubtedly hold it to be unreasonable restriction, then how is it a reasonable restriction for me?
Actions happen. You can comprehend what you're driving. The absence of a restriction per se. Today, if you say that today if this
No, I'm saying the silence is being read as a restriction. I'm saying, Malas, no, my Lord, I'm saying the silence is read in the counter and the stand of the government is a restriction. That's the meaning. Malas, I understand. I'm saying it's impliedly there. You have to read it there.
It's not so much a statutory silence as much as the failure of
To allow,
the
they're not going to allow
body
it.
to enact a law.
Well, it's more than failure to enact. They will not recognize. I'm not going to go in the market with the label of marriage only. If I do anything on the basis of that marriage, who's going to recognize it, Malas?
in argument. This flow.
No, that is the right part. I'm saying, Malas, their restriction. Third pillar is dignity. That is, Malas, very clear. Based on Article 21 as a third pillar or third facet. And Malas, there, everyone with equal concern and respect is the core of that dignity. If you were to, Malas,
Sorry, I just missed the point. I just missed the point. Sorry.
No, I'm saying the third pillar. We're done with those two
Dignity
pillars.
part of it.
The last one is, Malas, of course, the intersection. Of course, 14 is vital. in the intersection. And to what Justice Kohli also said, apropos Justice Bhatt, lack of recognition is actually a full restriction, de facto, de jure. Now, coming to the third pillar, dignity. Dignity, is Article 21, obviously resides there. And your Lordship has put it, differently, but the best, simplest way of putting it is to treat everyone with equal concern and respect, and not to send a message that any individual is less worth because of their ascriptive characteristics. That any group is less worth because of their ascriptive characteristics. And with it comes the ability to participate on an equal footing in social values or constructs. That also is a part of dignity. That's the entirety of dignity part. I only want to read one para as I leave dignity and come to the very important interpretation part. Just one para 40 of my written submissions. That is at page 438. I'm very grateful. 39 and 40 will also permit me. Does my Lord Justice call Justice? Chief Justice has got it.
Yes.
The central importance of marriage as a social institution, as outlined above, means that the ability to participate in it on equal terms is a question of dignity. When the state excludes a set of people from participation in a valuable social issue by comparing their choice with the state, proscribing what it considers noxious business activities, it communicates both to the excluded and to the rest of society that these individuals are less than complete members of society. It is therefore a message of subordination. I'm very grateful, my Lord's directed me and gave me an opportunity. Now, this is by way of analogy. This is not the case we are in. Just very quickly go through 40. It gives your Lordship 3 or 4, your Lordship juristic analogies. There are many historical instances of the exclusion of a group of people from a social institution being used to send a public message about their virtual moral members of society. These, for example, very well-known case, Venkatamana Devaru. Rules that prohibited women from participating in male professions, my Lord has already read it, so I'm leaving it, Anuj Garg. The refusal to accommodate disability in public examinations, I'm leaving it, Vikas Kumar. That's also by my Lord Justice Chandrachud. And many others. Over time, laws and the judgments of this court have removed these exclusions on the understanding that the ability to participate in the making and remaking of social institutions is central to individual dignity. The exclusion of LGBT, etc., from the social institution of marriage is one of the last remaining legal outposts that sanctions such exclusion. And therefore, it would advance the constitutional goal. This completes the 3 constitutional pillars and the ascriptive test. I now come to something very interesting, where in different contexts, in 3 judgments, in the House of Lords in the UK Supreme Court, one of the two judgments was very beautifully put. The issue arose, of course, it arose in the Rent Act in one case and some landlord relation in the other, that Parliament A did not intend it, or the text is a limitation, or the intent is a limitation, and how should we as a court read it? But fortunately, it arose, how should the court read it as a treaty-compliant legislation, not merely interpretation. In that, I'll read first one case, then a very, very well-written article, and then the other 2 cases. That's going to be, I believe, very profitable and repay study. First, turn to the House of Lords in a case called Gedan. Important. May I summarize it? Constitutional compliant interpretation of a statute oblique treaty compliant, because your Lordship is dealing with a treaty case, oblique treaty compliant which is their constitution. The treaty is their constitution. Constitution compliant interpretation oblique treaty compliant interpretation of a statute is not limited that statutory text or the legislative intent. But in a dynamic, evolving, only, the word only is important, only by trust of the legislation and by institutional capacity. And institutional capacity is explained, Manas. This is 113, 32. Vedan. I start with Ghedan, Malas, which is para 32 at 1136 of your Lordship's PDF of volume 4, which is foreign judgments.
Para 32.
1146. I'm sorry, I gave the wrong page.
But what is third part?
Just write down.
What page?
1146 of foreign judgments, volume 4.
Yes, what para you refer?
32.
1146? PDF.
PDF. Is it para 32? My learned friend says it is 1146, para 32.
Is 1146 is actually physical 1138.
38.
Physical 1138.
May I read? From this, the conclusion which seems inescapable is that the mere fact that the language under consideration is inconsistent with the convention compliant meaning does not of itself make a convention compliant interpretation under 3 impossible. Language to be interpreted restrictively or expansively. But section 3 goes further than this. Take out the page where section 3 is quoted. Take it out. It is also apt to require a court to read in words which change the meaning of the enacted legislation to make it convention compliant. Will my lord underline that? Lordship got that sentence? In other words, the intention of Parliament in enacting section 3 was, to an extent bounded only by what is possible, a court can modify the meaning and hence the effect of primary and secondary legislation. Well, I've studied in England, I could not imagine these words coming from an English court. Parliament, however, cannot have intended that in the discharge of this extended interpretive function, court should adopt a meaning inconsistent with a fundamental feature of legislation. That would be to cross the constitutional boundary under section 3. Boundary section 3 seeks to demarcate and preserve. So it's nicely balanced. Parliament has retained the right to enact legislation in terms which are not convention compliant. The meaning imported by application of section 3 must be compatible with the underlying thrust of the legislation being construed. Words implied must, in the frugal and learned friend Lord Roger, go with the grain of the legislation. Nor can Parliament have intended that section 3 should require courts to make decisions for which they were not equipped. There are several ways of making a provision convention compliant, and the choice may involve issues calling for legislative deliberation. Now, let's kindly come to para 51. Whereas this was Rent Act, the phrase was as his or her wife or husband. Now, this is very important. Let's just write down this sentence. It's a very important query which Lord is raised. What was the context? Identical to us. The phrase under the Rent Act was, just kindly note that down, Lordship will take my word for it, as his or her wife or husband. And the finding was that this phrase means as if they were his wife or husband. As if they were his wife or husband. That is the finding. In other words, they were not husband and wife, but we have to read it as if they were husband and wife.
Just see para 35, that's
Yes.
very interesting. He give you the facts and how they mold the.
Yes, may I, Minister?
The relief.
Lord Stein is very important. Let me read 35 first.
35.
In some cases, difficult problems may arise. No difficulty arises in the present case. Paragraph 2 of Schedule 1 of the Rent Act is unambiguous. But the social underlying the 1988 extension of security of tenure under Para 2 to the survivor of couples living together as husband and wife is equally applicable to the survivor of homosexual couples living together in a close and stable relationship. And this is a country doing a convention compliant interpretation with no constitutional history, hardly any constitutional jurisprudence and legal, and would do so consistently with the social policy underlying Para 2. Well, it's without Article 14. Without Article 14. Now, well, just read on. There's something more. I've not finished it. This is a very interesting case. And the article is even more interesting. How far? Now, just turn to Lord Stein, Malus, who's the next para. He, of course, the summary is better to see first, para 51, which is at page 1152. Anything else? Anything else?
Nothing.
I now return, it's at 1152, my Lord has got the
got
conclusion of Lord Stein.
You've got that.
I now turn to the circumstances of the case before this House. Applying Section 3, the Court of Appeal interpreted as his or her wife or husband in the statute to mean as if they were his wife or husband. While there has been some controversy about aspects of the reasoning of the Court of Appeal, I would endorse reasoning on the use of Section 3.1. It was well within provision. But Balats, possibly the best way of putting it was Lady Hale Balats, which is at 1177. The first Balats, woman Chief Justice, not right way to describe her, Balats, of UK. President of the UK Supreme Court. Which page is it?
1177.
1177. Well, it's 1177, para 130.
Seven, seven.
130.
130.
Para as well as 130.
30.
PDF
Okay, got it.
117.
Baroness Hale of Richmond.
May I read, Willis?
1177.
Yeah, para
11? I believe it's 1177.
They were on
Same volume, little ahead.
Baroness Hale of Richmond.
Well, she has put it in a wider one, but I will read Willis some paras on a wider basis, but also this basis.
Yeah.
And rather well put. Sure you've not left out any? It is, may I read, Willis?
9.
Yeah.
It is not so very long ago in this country that people might be refused access to a so-called public bar because of their sex or color of their skin, that a woman might automatically be paid 3/4 of a man what a man was paid for doing exactly the same job, that a landlady offering rooms to let might lawfully put a no blacks notice in her window. We must now realize that this was wrong. It was wrong because the sex or color of the person was simply irrelevant to the choice which was being made, to whether he or she would be a fit and proper person to have a drink with others in the bar, to how well she might do the job, to how good a tenant or lodger he might be. It was wrong because it depended on stereotypical assumptions about what a woman or a black person might be like, assumptions which had nothing to do with the qualities of the individual involved. Ascriptive. Even if there were any reason to believe that more women than men had bad customers, this was no justification for discriminating against all women. It was wrong because it was based on an irrelevant characteristic which the woman or the black did not choose and could do nothing about. Ascriptive. When this country legislated to ban both race and sex discrimination, there were, and we have here a Hindu prime minister and a Muslim first secretary in the north of that country. First minister, which is the equivalent of the prime minister within the sovereign system. When this country legislated to ban both race and sex discrimination, there were some who thought such matters trivial, but of course they were not trivial to the people concerned. Still less trivial are the rights and freedoms set out in the European Convention. The state's duty under Article 14, now it is interesting that number is the same, to secure that those rights and freedoms are enjoyed without discrimination based on such suspect grounds is fundamental to the scheme of the convention as a whole. It would be a poor human rights instrument indeed if it obliged the state to respect the homes or private lives of one group of people, but not the homes or private lives of another. Such a guarantee of equal treatment is also essential to democracy. Democracy is founded on the principle that each individual has equal value. Treating some as automatically having less value than others not only causes pain and distress to that person, but also violates his or her dignity as a human being. The essence of the convention, as has been said often, is respect for human dignity and human freedom. See so and so. Second, such treatment is damaging to society as a whole. Wrongly to assume that some people have talent and others do not is a huge waste of human resources. It also damages social cohesion, creating not only an underclass, but an underclass with a rational grievance. Third, it is the reverse of the national behavior we now expect of government and the state. Power must not be exercised arbitrarily. If distinctions are to be drawn, particularly upon a group basis, it is an important discipline to look for a rational basis for those distinctions. Classification, nexus, object. Finally, it is a purpose to all human right instruments to secure the protection of the essential rights of members of minority groups, even where they are unpopular with the majority. Minority includes minority in different ways on ascriptive characteristics. Democracy values everyone equally, even if the majority does not. Then, para 137. I hope you have not missed out anything, right?
I think you may read 135 also.
135. May I read it? I'm grateful. It is common ground that one of the convention rights is engaged here. Everyone has the right to respect for their home. This does not mean that the state or anyone else has to supply everyone with a home. Nor does it mean that the state has to grant everyone a secure right to live in their home. But if it does grant that right to some, it must not withhold it from others in the same or an analogous situation. This is the heart of equality. There's no positive obligation that says I must give you a house. It must grant that right equally unless the difference in treatment can be objectively justified. You're granting marriage to heterosexual couples. Give me a rational reason to deny it to this side of the table. There is no need for us to express a view on the degree which a constitutional right must be engaged in order to bring Article 14 into play on any view that threshold is crossed here. It is also common that there is a difference in treatment in respect of that right between the respondent and the survivor of an opposite sex relationship. It is also common ground that sexual orientation is one of the grounds covered by Article 14, on which, like sex and race, a difference in treatment is particularly suspect. Well, this is that facially suspect, which Your Lordship has said. Yeah. Facially, for the reason given earlier, the grounds put forward to justify it require careful scrutiny. Now, 137. The parties differ on whether the survivors of an unmarried heterosexual and homosexual couples, so he's dealing with unmarried and homosexual couples both, are indeed in an analogous situation, and therefore on whether the basis of the difference in treatment is sexual orientation or something else. Impossible to see what else the difference can be based on. Impossible to see what else the difference can be based on except sexual orientation. Everything which has been suggested to make a difference between the appellant and the other surviving partners comes down to the fact that he was of the same sex as the deceased tenant. It is the decisive factor. Then, 38, in fact, I'll also read. We are not here concerned with the difference in treatment between married and unmarried couples. The European Commission accepts, etc. May I, come, if I don't miss out something relevant, fellows. 142, I think, will suffice. But let's just see 141, the first few lines, not the whole. 141, a few lines. There are some important things. The relevant difference which has been urged upon us is that a heterosexual couple may have children, whereas a homosexual couple cannot. But this too cannot be a relevant difference in determining whether a relationship can be considered marriage-like for the purpose of Rent Act. First, the capacity to bear or beget children has never been a prerequisite for a marriage in English law. It's a very interesting history, Mills. Henry VIII, a very infamous ruler with 6 wives, Mills, would not otherwise have had the problems he did.
Not together.
No, but Manas, no. What she's saying is, Manas, that sequentially, only because of lack of children.
Right.
And Manas, in his case,
Lack of heir.
lack of an heir. And in his case, Manas, lack of an heir meant sometimes execution of the lady. That's how, Manas, this is called, she's referring to sequential. She put it rather, Manas, in the typical English understatement. Henry VIII would not otherwise have had the problems he had. It's an put it very nicely, Willis. Even the capacity to consummate the marriage only matters if one of the parties thinks it matters. If they are both content, the marriage is valid. A marriage, let alone a relationship analogous to marriage, can exist without either the presence or the possibility of children from that relationship. Secondly, however, the presence of children is a relevant factor in deciding whether a relationship is marriage-like. But if the couple are bringing up children together, it is unlikely to matter whether or not they are biological children of both parties. Both married and unmarried couples, both homosexual and heterosexual. I'm sorry. Both married and unmarried, both homosexual and heterosexual will bring up children together. One or both may have children from another relationship. This is not at all uncommon in lesbian relationships, and the court may grant them a shared residence order so that they may share parental responsibility. A lesbian couple may have children by donor insemination who are brought up as children to them both. It is not uncommon for each of them to bear a child in this way. A gay or lesbian couple may foster other people's children. When the relevant sections of the Adoption Act of 2002 are brought into force, they'll be able to adopt. This means they will indeed have a child together in the eyes of law. Thirdly, there is absolutely no reason to think that protection given by the Rent Act to the surviving partner's home was given for the sake of couples' children. Statutes usually make it plain if they wish to protect minor children. These days, the succession is likely to take place after any children have grown up and left home. Children, whether adult or minor, who are still living in the home may succeed as members of the family under so and so of the schedule. It is the long-standing social and economic interdependence, which may or may not be the product of having brought up children together, that qualifies for the protection of the Act. In the days when the tenant was likely to be a man with a dependent wife, it was understandable that preference was given to the widow over anyone else in the family. But in 1980, that preference extended to widowers, whether or not they were dependent upon the deceased wife.
Dr. Singhvi, we have a similar case, except that it's not same sex. Here was a case where, in the absence, marriage was not essential. Person was living with the original tenant.
Yeah.
The tenant died.
Yes.
So the live-in, whoever was a partner,
Like you're not married.
not married. So therefore, that protection was sought to be taken away.
More importantly, how would you read the act, which might violate your
judgment by Justice Lahoti before the domestic, violence act,
Yes, I'll have
where
that.
they were
Just take
where
that.
the parties got estranged.
I'll cite that tomorrow. I'll let.
So, and then the husband, he actually intentionally walked away, and then the wife faced eviction.
Eviction.
The court granted that protection.
Now see what is the next para. I'll place that. Just see the next para. Now 142 onwards is where I particularly wanted to read. Homosexual couples can have exactly the same sort of interdependent couple relationship as heterosexuals can. Sexual orientation defines the sort of person with whom one wishes to have sexual relations. It requires another person to express itself. Some people, whether heterosexual or homosexual, may be satisfied with casual or transient relationship. Now, this is another important facet I forgot to mention: casual or transient relationships. It is to avoid them that marriage is an important aim or object of some people. It requires another person to express. But most human beings eventually want more than that. They want love. I started the case arguing today with that one. It's the right to love, person of your choice. And with love, they often want not only the warmth, but also a sense of belonging to one another, which is the essence of being a couple. And many couples also want to come the stability and permanence which go with sharing a home and a life together, with or without the children, who for many people go on to make a family. It is, in this, people of homosexual orientation are no different from people of heterosexual orientation. It follows that a homosexual couple whose relationship is marriage like, look at that word, Manas, marriage like, in the same way that an unmarried heterosexual couple's relationship is marriage like, are indeed in an analogous situation. Manas, I can continue. There's something more here, so I'll continue tomorrow, Manas, on this. Spara 143. Well, I'll be as fast. I'm not repeating anything. Just the reading time will take some. I'll be as fast as possible. I've taken those comments. I will not take time. I'll do it. If your lordship would permit me, I can do it virtually, but otherwise I'll be here physically. Your lordship would say it. Very well.